This is one of those questions that attorneys ask quietly, usually already after they've had a fee dispute in the past. Do you actually have to disclose past fee lawsuits on your malpractice insurance applications or at renewal time? Or is it something that I could leave off because it was handled, it didn't turn into anything, or it was paid and it's already resolved and it happened a couple years ago? The short answer is yes, you have to disclose it. But the way it's disclosed and how it's explained matters more than you think. Insurance applications aren't just annoying paperwork, it's how your malpractice policy is underwritten. When a carrier reviews your application, they're not only looking for prior malpractice claims, they're trying to understand patterns, how disputes are handled, how often issues escalate, and what are the risks that might show up next. Fee lawsuits fall into that category even if they did not turn into a malpractice claim. Failing to disclose them can create a bigger problem than the fee dispute itself ever did. Many applications don't flat out ask, have you ever been sued for a malpractice? They ask broader questions like these. Have you been involved in any disputes with clients? Have you pursued or defended fee litigations? Are you aware of any circumstances that can reasonably arise in a claim? From an underwriting standpoint, a past fee dispute fits within those questions. Carriers aren't trying to catch attorneys doing something wrong. They're trying to understand how conflict shows up, how you manage it in your firm, and is it a pattern that could possibly come up again in the future? And so here's where firms can create some unintentional exposure. If a past fee suit later connects to a malpractice allegation, even years down the road, carrier is going to look back at that original application. If that dispute wasn't disclosed, the firm could face coverage complications, rescission issues, or even claim denials. Even when the original fee case seemed minor or routine, non-disclosure can undermine trust with the insurance company and make your renewals far more difficult. From a risk management standpoint, non-disclosure is often far worse than just disclosing what's happened. Sometimes attorneys often assume that if the fee dispute was taken care of, we don't need to bring it up. And resolution of the fee dispute does matter, but it doesn't automatically remove the disclosure obligation. What carriers care about is whether or not the fee dispute actually occurred and whether it reflects a broader pattern of escalation. A resolved matter that's properly explained is far less concerning than an undisclosed problem that resurfaces later. Context is everything when it comes to your malpractice insurance. And so disclosure doesn't mean oversharing, and it doesn't mean airing out your firm's dirty laundry. The goal is to provide clear, factual context about what happened. Carriers want to know what happened, how it was resolved, and what changes, if any, were made afterward. Insurance companies are far more comfortable with firms that acknowledge issues and demonstrate control than firms that avoid disclosure altogether. If handled correctly, a fee dispute doesn't automatically derail your malpractice insurance. At the end of the day, insurance companies love predictability. They want to know that your disputes don't routinely escalate, that your engagement terms are clear, and that the firm has processes in place to manage breakdowns in the attorney-client relationship. And the way you disclose your process helps them assess that quickly. If you're looking for a partner that invests in your risk management so you can grow your business safely, at The Bunker, we love to help businesses move from danger to a safe place. Click the link below and we're happy to help.